Everybody, welcome to the Regulatory Task Force. We have a roll call.
Senator Driscoll.
Here.
Senator Jones. Here. Senator Schuler. Here. Representative Davis.
Excused.
Representative Stith.
Here.
Representative Yen.
Here.
Director Matthews.
Here.
Director Parfit. Here. Mr. Baybout.
Here.
Ms. Delancey. Here. DeLacy. Mr. Martin.
Here.
Ms. Olson.
Present online.
Mr. McKay. Mr. Napier.
Excused.
Mr. Malm.
Excused.
Co-Chairman Guru.
Here.
Chairman Nicholas.
Here.
Mr. Chairman, you have a quorum.
Thank you. Alice, why don't you give us an update, schedule out our day, what we're going to do. Dave, go ahead.
Thank you, Mr. Chairman. David Hopkins with the Legislative Service Office, just taking a quick look through the agenda today. Mr. Chairman, one thing to highlight on the agenda is the approval of previous minutes. We'll need to address that next. But then we'll be jumping into some zoning protest petition bill drafts. There are 3 versions of the bill for that bill for the committee to look at. And then building timeline permit bill drafts. Again, 3 versions of those bill drafts for the committee to be looking at this morning. Then we will move into mitigation and exaction fees bill draft and a family dwelling stairwells related bill draft. And then following lunch, we'll be hearing from Jason Crowder with the Office of State Lands and Investments regarding the state lands leasing program, just an extension of the conversation from the previous meeting. We'll hear an update from the town of Jackson on their permit mitigation fees. Again, these are kind of extensions of previous conversations. And then a housing update on the J.H. Hereford Ranch and the Teton Habitat and Housing Trust. And that would take us through today.
Okay, any other introductory remarks or hellos, Mr. Co-Chair?
Thanks, Mr. Chairman. Yeah, welcome everybody and thanks for being here. The good co-chair and I talked a little bit last night about this. You know, this has been a really overarching project and we've kind of geared a lot into the housing and planning realm. And as we talked about it, we just feel like we're just scratching the surface and unearthing a lot of issues. Some involve communities that have a great deal of experience with this, but the majority of communities in our state are less so, and everybody in between. And so the question is trying to figure out, and what a lot of what we've been going through with, and why you see a lot of bill drafts, why you see a lot of different views, is addressing some of those issues. Some very macro, some very micro in scope. And so as we go through this today, I guess it's kind of leading up to, you know, this subject needs more work. Housing is such a critical issue. And the other issues that we tackle too in the energy sector too are very critical as well. But this housing issue is critical to all of us, whether it's quality housing in some communities versus affordable housing in others, versus density versus more of a rural way of life that we're very used to in Wyoming, and how all those questions, how they work together. So I guess my point is we're getting to the end of our time in this session and want to kick some bills out to try to get some action in legislative committees as we move forward. I hope this work will continue. I hope in the next session, the leadership allows this group or a different version of it, if they so choose, to move forward, because these issues need to be addressed and we need to continue to have this conversation. And so with that, I know we've got a lot of work to do in a short amount of time to do it, but I think this group can. Let's center on what we can get done. I'd like to see us, like say, try to get something out if possible and move forward. and then try to talk to our friends in the incoming, next session, 68? It's in the 68, to see if we can move this forward. So with that, Mr. Chairman, thank you.
Thank you, Mr. Co-Chair, and just to follow up a little bit on that. Obviously, this committee probably will not meet again. We may, if that's the consensus. But if we don't, we have to pick the committees, the bills, drafts that we approve or to move forward. We have to make, and what those committees are and what they're going to do with them, we can't control. All we can do is do our best on what's in front of us and come up with suggestions on it. The bill drafts, I believe, probably require more work, but that's the legislative component and LSO components to make, to fine tuning the bill to make them so that they're ready for the floor of the respective bodies. But in general, the idea of regulatory reduction is on everyone's mind to some extent, to make the cost of housing cheaper, less expensive, faster, because that's one of the things that we can do as a legislature. Local control is a wonderful thing, but sometimes we get in our own way. So that's kind of the purpose of this committee. So thank you all for being on part of this, and let's we'll just jump into the bills, but please, all your comments, any ideas and suggestions or future suggestions on what this committee or what we can do as a task force would be appreciated as we move forward. So let's go up to our first bill, which is 85, is that right? Come on up, please. Morning.
Mr. Chairman, members of the task force, Talise Hanson, staff attorney, LSO, presenting the 3 zoning protest petition bill drafts. I'll start with the first one, if you would like that. Okay, so the first one is 25 LSO 85, version 0.4, zoning protest petition amendments. Section 1 of the bill draft amends Wyoming Statute 15-1603A, which is the zoning protest petition statute. Page 2, line 3, strikes 20% of the property owners required to sign a zoning protest petition and inserts 50%. Page 2, lines 7 and 8, strikes the requirement of an affirmative vote of 3/4 of all the members of the governing body for proposed change to become effective, and replaces it with a majority of all the members of the governing body. Section 2, on page 2, lines 12 and 13, provides that this act shall apply to protests filed on and after July 1st, 2025. And section 3 on page 2, line 15, provides an effective date of July 1st, 2025.
So committee, on this first bill, as you can recall, the 50% was a placeholder and the majority was a placeholder. So what I'd like to do before we go on to the next bill is open it up to the floor discussion on what those percentages or numbers would be and any recommendations that this committee wants to suggest. And so with that, just open up for discussion. I mean, 30%, 40,
Yeah, Mr. Chairman.
please.
Yeah, Mr. Chairman, the question I have is on the 140 feet. Is that standard? I know that's been in our statutes for a long time where that's a limitation on the distance. The percentages, you can play with those, but that 140 feet might be somewhat limiting. Is there any background or any information someone could share with me as why it was in there in the first place, and if that's significant or not, and should we be looking at that?
Go ahead.
Mr. Chairman, Mr. Bebout, I'm not exactly sure. I'd have to look about when that 140 feet was put in there, or whether it was in there when the statute was first enacted. But the memo that was provided last meeting, Wyoming is at 140 feet, and the other states range from 100 feet to 1,000 feet.
So Eli, do you want to change it to 145?
Yeah, not yet, Mr. Chairman. Just curious as to why 140, but I think that answers my question. It's all over the place depending on where you're at. That's kind of what I thought it would be.
Yeah, okay. Further discussion on the numbers?
Mr. Chairman, in looking at the three bill drafts, I think taking one at a time might be a little challenging for me. The third one would be my preference, which is a complete repeal. The conversations that I've had and some research that I know that has been done, this was a protective statute that was put into place decades ago to keep the towns from growing out into the ranch lands. And while it is very effective, and in the times that it does get brought up, most recently in Laramie this summer, it required, the 20% stood up and said they were opposed to the potential zoning change. And when that forces the 3/4 vote, my understanding is it lost by 1. And so we either need to repeal it entirely, which would be my preference, or I think the 50% and the majority is effective in making sure that the silent majority in most communities is able to have their place in the process. Thank you.
So, let me address your first comment first. The simpler the bill, the simpler we make it, the more likely of success. The problem with bill number 3 is it's a comprehensive change, which is going to be a harder pill to push down the throat. So, thus the need for multiple bills, I think. So, Representative?
Mr. Chairman, so as far as the numbers go, it seems that on page 2, changing the 3/4 to a majority, that makes a lot of sense. Changing the 20% to the 50% seems like it might be going too high to go to 50%, because it could be really difficult to gather the signatures of 50% of the owners of the lots in an area. There, I believe, in the Special Improvement and Service District Act, there's a similar kind of 30% threshold for vetoing proposed improvements or for protesting proposed improvements. So I'm imagining a situation where you've got maybe someone proposes a gravel pit next to a residential subdivision. It might be hard, and if you're in an area where a lot of the people don't live there year round, for example, it could be hard to collect 50% of the signatures of all the owners by land area. So I don't have a magic number. I do like the change from 3/4 to majority. That makes a lot of sense to me. So I would think something between 20 and 50 would be more appropriate.
Any discussion on that particular issue? And generally, I would concur with those comments. Any feedback? When everyone jump in here, let's go. Let's have some fun. Go ahead, Wendy.
Thank you, Mr. Chairman. I actually kind of prefer the 50%. I think if you're going to make a change in regulation and some of these protests that have happened, it should be a high bar. And you should have to go, and visit with a number of your neighbors to find out, to let them know why you're protesting. And I like the idea, Mr. Martin, of the silent majority, not only just for the majority of the members of the governing body, but also 50%. I think the 20% was too low. I could live with 40, but 50% makes more sense to me. Thank you.
Mr. Chairman, thanks. I actually also preferred the full repeal bill. I think we should just clean up the green books, and if a town or county wants to have a protest process, they can just implement it themselves. I don't think we needed to have it in state statute ever. I do think that if we do want to keep this in place, we should. I'm in favor of the 50% and the majority portion. I also think we could pass more than one bill and give it to a committee decide whether they think it's a big enough lift for the legislature or not. So I think we could recommend more than one. Thanks.
Go ahead.
Thank you, Mr. Chairman. I really feel very strongly in support of the comments made by Senator Schuler as well as Representative Yin by maybe having more than one option as we move forward. And then also, you know, this notion of the 50% and the bar being high. You know, like for me, I think really what is before this committee is really a fundamental question as far as, do we want to give a vehicle for people to exercise their private property rights and do what they want with their property, or do we want to put the power in the hands of the naysayers? So that's really where I think that question kind of comes down to what that bar should be. But 50% and majority based, you know, like the comments that Senator Schuler made makes a lot of sense to me. So I think also we should have maybe more than one option for the next legislature to consider.
Mr. Napier.
Thank you, Mr. Chairman. I really appreciate the dialogue on this topic, and I do like the changes that the first bill proposes. However, I would have to say from a practical standpoint, the protest petition is really not responsible for a lot of the changes that have occurred on a legislative level, particularly at the local level, with regard to protecting neighbors' concerns and so forth. And so the reality is a protest petition just doesn't have a lot of practical purpose. And so from my standpoint, I would say let's get rid of it totally, go with a third option. But if that is just simply not possible, the changes proposed in the first bill, I would endorse.
Okay, further comments? Do we have any public comment on this first draft, on the first bill? Come on up, Bob. Anybody else who wants to speak, come on up so we don't have to wait for everyone to get up here. Welcome.
Good morning, Mr. Chairman, members of the committee. I just wanted to take the time real quick to introduce myself to you as the new Executive Director of Wyoming Association of Municipalities. Just wanted to give you a heads up. Oh, Ashley Harpstreet. I am here to learn with my Jedi Master here and our Legislative Director, but just a warm introduction to WHAM. We are a 501c6 private nonprofit association that provides educational resources to all of our 99 municipalities. Since 1967, WHAM's mission is to advocate for cities and towns and their common interest that WHAM supports policy that aligns with local decision-making. So we'll be seeing that over and over today. We want to keep that closest to the 68% of the people that live within the municipality borders. And with that, Mr. Chairman, I'd turn our comments over to Mr. Bob.
Mr. Chairman, good morning. Bob
Mr. Jedi Knight, please proceed.
Yeah, right. I'm Bob McLaurin. I'm with WHAM. I'm the legislative director here. With any of these bills, we can live with any of them. We think that our local elected officials do a great job making hard zoning decisions. And any of these bills, in our view, will strengthen their ability to make zoning changes. We prefer the repeal, but if that's not something that the committee wishes to do, we can live with any of these changes. So with that, I'd be happy to answer any questions, Mr. Chairman.
So just for our edification, if we repeal, where does that leave the law?
Well, it would seem to me, and I'm not an attorney, but I would believe that the city could establish by policy and procedure a petition process. If they don't do that, then an appeal of a zoning decision would go to the district court. But having been involved in a number of local zoning disputes, the council has a very hard decision to make, and then there's a petition filed, and then they have to do it again. And the fact of the matter is, most of these cities change zoning by ordinance. And with an ordinance, you have 3 readings of an ordinance. And in many cases, a lot of the people that are protesting wake up at the last minute after this has been going on for 2 or 3 months and go, oh my God, what's gonna happen? And so you sort of a last minute knee-jerk thing. So like I said, I think a city, if they wanted to do this, could do it. It's not gonna be a requirement. And I think one of the bills gives the cities a chance, gives the option to decide their own, percentage, and if they don't decide, I think it's a 50%. So any of these we can live with, Mr. Chairman.
Okay, further questions for a Jedi Knight before we move on? Okay, thank you. Any other public comment?
There it is. Good morning, members of the committee. Mr. Chairman, members of the committee. My name is Jim Manley. I am the State Legal Policy Director for Pacific Legal Foundation. PLF is a nonprofit law firm that was founded 50 years ago by members of then Governor Reagan's staff in Sacramento. And since then, we've litigated a number of cases before the U.S. Supreme Court involving property rights. I'm here mainly to speak on the exactions bill, but I wanted to emphasize one point on these bills that was brought up in the last bit of testimony. This bill and actually the shot clock bill are 2 things that we've identified as really important in solving the housing crisis in this country, which we are well aware exists in Wyoming as well. And one important aspect of solving the housing crisis is limiting the ability of a handful of people to append local land use decisions. And so what I want to emphasize for the committee is that if the protest procedure is eliminated completely, that is good for moving forward with local land use decisions. If all guidelines in state law are eliminated, then local governments can do whatever they want, and they could set up a procedure where a single person could protest and require unanimity to overrule that single protest. So I would urge, if the committee does adopt one of the bills, that to include some sort of baseline threshold so that cities cannot create that one-person veto authority. Thank you. Happy to answer any questions.
Thank you for your testimony. We appreciate it. Any questions for Mr. Mann? So I think you hit the nail on the head, and the question is 20 or 30 or in 140 actually is almost more impactful than the percentage concept. So that's the issue that we're struggling with. So.
And I'll just add, Mr. Chairman, we focused on this issue as lawyers, looking at the ability of folks to sue to append these local land use decisions. And so our model legislation on this deals with that issue, that standing to sue, where you have groups who aren't harmed by the decision jumping in to sue in order to delay. And so that's one aspect that the committee might consider in tweaking the language is to include some element of harm for folks who are protesting. Generally, that's going to be obvious if you have the sort of restrictions on distance, but not always. And so it might be worth considering that sort of language that requires protesters to demonstrate some individualized harm.
Some type of a standing issue. Okay. Well, any other questions? Thank you very much for your testimony.
Thank you.
Any other public comment on this first bill? The other ones get more complicated, so. This is the easy one. Come on up.
Mr. Chairman, Chad Auer, Governor's Office. Just the point that I wanted to emphasize is that even if there was a full repeal, public participation in the process is not eliminated. In fact, as our friends from WAM mentioned, that when the process from a application to when a duly elected board makes a final vote, incorporates all kinds of opportunities for people to participate, even if there was a full repeal. That's all.
Any questions for Chad? Thank you, appreciate it. Any other public comment? So committee, we'll close public comment. What's your pleasure on this bill? Moved by Wendy, seconded by Mr. Co-Chair.
Mr. Chairman,
Please.
where do these are these bills being recommended to any specific committee?
So the answer to that is, our obligation on all of these bills as a committee is to refer them to a standing committee, correct? And we all know that there's going to be some shifts in the standing committees between now and the session. So in order to have these land in a place where they're most likely to succeed, I think my recommendation is going to be that the co-chairs meet with the standing committee chairs and to determine where they're going to go. We don't know the answer to that question, I guess, at the present time. Before the primary election, I would have said we're making JAC bills. That the JAC is going to be a completely different structure than starting in January. So the answer is we don't know the answer to that question. If that helps. If you got any suggestions, let me know. Wendy, go ahead.
Thank you, Mr. Chairman. I think, after looking through all three of them, I was leaning towards a different one at the time, but I kind of like this particular bill because of its simplicity. And I believe that it does provide the consistency that towns and cities need. Because I think if we don't have anything in place and then we go willy-nilly, you're gonna see those single protesters in a small town that are gonna really maybe upend potential for growth. And so where this one is right now, I feel very comfortable with. Thank you.
Thank you.
Mr. Chairman, I think one more comment is the ultimate goal is to try to help provide developer certainty so that they're willing to make financial investments. And while this may not be used often, when it is used, it's used effectively, and leveling this playing field will help provide certainty for the developers to be willing to go from first base to second, if you're going to use a baseball analogy.
And so in that regard, I do have a question that I'll pose to you. It looks to me like the most powerful element of this is the 140 feet versus the percentage-wise. But from a practical standpoint, do we know the answer to that? By the way, we have Mr. Davis is online, just if everyone's confirmed. Okay.
Mr. Chairman, I don't know that I do know. From the perspective of residential development, which is where my heart is, when it happened to me, and it did happen to me, it was the folks that were in the neighborhood adjacent that were upset because their grandson wouldn't be able to continue to trespass and ride their bike on the property, and that they didn't know that they were going to be able to control the type or manner of the housing beyond what the R1, R3 zoning might end up being. And so it's typically within the 140 feet are the ones that are the closest to it. It could be changed, but I don't have any real opinion on what a better number for that would be.
And what we do know is that we're on the low end of the spectrum compared to other states, statutorily. And it allows basically 2 or 3 landowners to make that decision. And the question is that, in terms of regulatory reduction, is there a better number? And so I would just pose that question to each of you as we, if there's a better number, now's the time. So any amendments? Any proposed amendments?
Mr. Chairman,
Please.
prior to making an amendment, I just wanted to ask, just a little further flesh out the discussion about the 140 feet, because it sounds like what you're saying is if you make it a bigger number, say 500 feet or 1,000 feet, then at least you're going to have a lot more people in the process, as opposed to having just the handful of residents who are near the vacant area who want to be able to ride their four-wheelers on the vacant land. Whereas people who are if there's 1,000 feet, that's going to be, what, 3-4 blocks away? I don't know. I mean, I don't have a particular solution, but I do recognize the problem that you've got potentially very few people. And so then the 50%, 40%, whatever makes less difference because you're only talking about a handful of people potentially. So it seems to me that maybe this number should be higher in order that you get a little more sense for what the community wants.
So what's the length of the average city block? John?
Mr. Chairman, just trying to pencil it out and think of the neighborhood north of here where I live. Typical lots anywhere from 35 to 50 feet, and there's 4 or 5 of them on a block, and so you'd be 140 feet would probably be a typical city block. I can go look on county records and take a gander at it.
Thank you, Mr. Chairman. I don't have the answer to your question about the length of a city block, but just for discussion's sake, do we even need to have that clause in, like, do we need a number? Should we just maybe stop at the comma before the or, which would potentially go to Representative Stiz' comment about, like, if we just stopped at 50% or more of the area of the lots included in the proposed change, period. And then, just eliminate with the or those immediately adjacent. Like, that's what's opening up this next category of commenters per se, and just leave it to, the district boundaries sound by the owners of the 50%. Is that a possible solution or no?
So that's a good question. And that's part of the issue that we're going to deal with in the next 2 bills is if you have a subdivision plan is one thing. If you have a house change of use or adding one more home within a block, should it have the same type of guidelines? I mean, because who you're affecting are, so that there's a reason to have the 140 feet, I believe, just because of the size of the project. That is my kind of just counterpoint to your question, to your statement.
Mr. Chairman, just taking a quick look, the street I live on is 370 feet east to west by about 320 feet north to south. And so 140 feet would seem to be actually quite small and could certainly be expanded in an amendment to this bill.
Further comments? Or suggestions or amendments?
Mr. Chairman.
Please.
Well, I'll try an amendment, then we can just get it out there and discuss it. On page 2, line 6, change 140 feet to 500 feet.
Is there a second?
Second.
Move in second. Discussion.
Just the reason why, just to build on what we were just talking about, I think we do need to have something there. And I think 500, if going on the information that we have, I think 500 feet is encapsulate, and leave the 50% alone. Just say that I think that gets us into a wider scope so we can get that kind of neighborhood input to go back to what you were discussing as far as that type of example.
Mr. Chairman, and for Senator Grew, I take it that you would also want a conforming change in line 9?
Yes.
Thank you.
So
yes.
What you're referring to is a majority versus 3/4. Is that correct?
Mr. Chairman, no, it's just the 140 feet shows up
140 feet
twice
above
on the
that,
page, in line 6 and on line 9.
Right. Everyone understand the amendment? Any further discussion on the amendment? All those in favor say aye.
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 Those opposed? That motion carries. Do we have, as currently drafted, we have 50% and majorities, so any other amendments? Please?
I'm interested in the idea that we just heard about related to harm, because I think by expanding this, I understand that ideally what we're doing is creating a larger community conversation about a zoning, an amendment, or the allowance of a change to a zoning ordinance. And it makes me a little bit nervous, again, when we're trying to create certainty or developers about this process. Are we helping with certainty with this? And I like the idea that there's maybe some other standard that we can bring into this related to harm, because I don't know about the rest of this committee, but I don't know my popularity in my neighborhood. And this just allows people to protest my change. If I want to put an ADU in on my property right now, I have a double lot a few blocks from him, and you know, a double lot with one home on it. But if I want the ADU right now, I need the amendment. And if, you know, just because my behavior hasn't been great around the neighborhood, do we just make it that much harder for me to move ahead? Not on the basis of a reality, but just because the people who could protest my change don't have to have harm. They could just not like me. And, you know, not that I'm saying that needs to be our standard, but I'm just worried we're not necessarily helping completely with certainty yet. So I don't know if I've got an amendment, but I think, is it possible that at least if we send this along, that we recommend a consideration of the harm discussion be included by whatever committee takes this up?
Go ahead, Cindy.
Thank you, Mr. Chairman. I know we closed public comment, but perhaps could we recall our second witness to maybe offer some opinion on this?
Sure.
He might have some guidance for us as far as we struggle through this. Thank you.
And any other witnesses? Mr. Manley.
Thank you. Mr. Chairman, so I pulled up our model legislation on standing to file lawsuits to challenge zoning approvals and other building permit approvals. One potential change would be to adopt language that's similar to our model, which would, I think, you know, on line 6, you could simply add an additional requirement describing who can bring the challenge, which currently it's owners of the area of lots included in the proposed change, or those immediately adjacent within a distance of 500 feet, and who can, this would be the new language, demonstrate a concrete and particularized harm to their property.
Any further questions? So the last statement, a particularized harm, that could just be a devaluation of property, right?
Mr. Chairman, I think potentially, yes. And this is a standard that's pretty common to federal courts to demonstrate a concrete and particularized harm that, you know, not just anyone can walk into federal court and sue over anything. You have to show that you're particularly uniquely injured. But it would certainly address, you know, Mr. McKay's poor relations with his neighbors.
Motorcycles are different, though.
Mr. Chairman, so I like the concrete and particularized harm. Does it have to be harm to their property? In other words, could you just have it be, and who can demonstrate a concrete and particularized harm? So for example, you can imagine if the harm because showing harm to property you'd have to show if you're 2 blocks away, you'd have to show that your property is actually devalued. And that could be really challenging, even if you did have a legitimate harm that you were experiencing due to, the fact that they're going to put an asphalt manufacturing place and there's going to be the dust that you're going to inhale or something or whatever. Maybe you've got a respiratory disease. I don't know. So question for Mr. Manley, do you believe that you need the limitation that it has to be harm to the property?
Mr. Chairman, Representative Stith, I think the way you've described it is a slightly broader standard. And I think any requirement to demonstrate some concrete and particularized harm avoids these sort of petty, we just don't want development objections. And so yes, you could narrow the restriction to say it's any sort of harm, not just harm to property. But I think you'd still be achieving some of the same goal of narrowing the types of objections that could give rise to this sort of protest.
Further questions? Mr. Manley? Okay, back to the amendment. Any further discussion?
Mr. Chairman, I don't recall, I'm not sure we have an amendment on the table, do we, or we do? We do,
No.
You're shaking no.
Do we have an amendment?
Right, okay, can we I move that we insert this certain and particularized harm in place of the numerical value on, what line is it? Line 6. After, I'm sorry, line 5, or those immediately adjacent, that we have this language to include particularized and concrete. Was the term, was it?
I think the way that you read it, you have a distance and a description.
Oh, I'm sorry, Mr. Chairman, that was my intent, yes. Distance and intention.
Yeah, and the language that I would suggest is concrete and particularized harm.
So then walk us through that suggestion again with the feet that you used and then incorporating into the, we have the majority of those individuals, or it's an or question, but just so we understand what the proposed amendment is.
Yes, Mr. Chairman, and I'm writing this on the fly, so.
Yeah, so are we.
So it would read, beginning at line 3, owners of 50% or more of the area of the lots included in the proposed change, or those immediately adjacent within a distance of 500 feet, who can demonstrate a concrete and particularized harm. I suppose we should add.
Second.
Yeah.
Go ahead. Discussion, go ahead.
Mr. Chairman, so I'm a little confused on how we can determine how many people that is. If you have to show harm, how do we know what percentage of people who are actually harmed, so we know it's over that 50%? Or if only one person says that they have harm, and does that meet that 50% threshold? Because now they're in that class of people within that area that can show harm.
Well, and just to add on to that, if you have one owner who owns 3/4 of the property within 500 feet, it's not a majority then. I mean, that means you could have someone who owns one lot effectively overrule someone who owns 75% of all the property, right?
Mr. Chairman, as I read it as 50% of the area of the lots, I think that applies. I think that's staff's reading, as I recall from the last hearing as well. So just
Okay, do we understand what the motion is on the amendment?
Question.
Go ahead.
So Ms. Delancey amended the amendment, correct?
No, it's a new amendment.
Oh, it's a new amendment,
Yeah.
so not, okay, because there was an amendment on the floor we passed, that's what we passed.
We
it.
passed
Okay,
it.
so now we amend that, okay, I got it now, all right. Just want to make sure I had it, all right.
Please.
Mr. Chairman. Mr. Manley, do you think we need the 500 feet? If we add that verbiage in there, do we still need that increased area?
Mr. Chairman, Senator Jones, it may, I think Representative Yen's concern might be addressed by adding an "and" in there, so that it's these numerical factors and a demonstration of concrete and particularized harm. I think that might get at what the confusion that we're working out here. So it would be both things. It would be either 50% of the land area, or 50% of the area included, or 50% of the adjacent lots within 500 feet, and who can demonstrate a concrete and particularized harm. So you'd count the land, without regard to harm, and then you just showing the harm would be an additional factor that the protester would have to demonstrate.
For both options. Is that what you're saying?
I think so, yeah. Yes, Mr. Chairman. Obviously, if your land is included in the area of the proposal, then harm is probably going to be easier to demonstrate than if you're an adjacent property owner.
So, Mr. Lansing, is that then your amendment?
That is, Mr. Chairman, my amendment encompasses the language stated with the two elements as articulated, so the 500 feet and the concrete demonstration of concrete and particularized harm.
So I think what we need to do is have this read back to us and how it would read, because it's a substantial change in current law by doing this proposal. So to understand it, I think we need to digest it a bit.
And
So,
Mr. Chairman,
go ahead.
so if I understand it, the original amendment that said who can demonstrate a concrete and particularized harm, that applied to the people in the buffer zone, the 500 feet area, right? But the way originally the amendment worked is that essentially harm is presumed basically if you're inside the land that's being rezoned or re-regulated, right? This alternative would require that even if you're inside the land, you're an owner of the land that's going to be rezoned, you still have to show a concrete and particularized harm, just so we're clear on what the change does. It seems, to me, it seems a little too far to do that, because if you're inside the zone, it could be really hard. If you live in the area that's going to be rezoned, it could be hard to show that you're being harmed by it, because the zoning might actually make your land more valuable, right? I mean, it might actually, because it would allow you to, build multiple housing units on it and actually increase the economic value of it. But you, as a landowner inside this land being rezoned, may not want that, right? So I think this proposed change is kind of a big deal, is what I'm saying.
Yeah, that's why I'm asking further discussion, because I would agree. I mean, as I think it's a little bit too far. Go ahead.
Yeah, and the question I have, who decides if you're materially harmed? Does the governing body decide that, or is there some, how does that work?
Mr. Chairman, that just is an additional.
It's a legal question. So ultimately, the courts would decide what that means, and there are standards of proof of what that is. But it's not an easy thing to do. Let's just put it that way. I mean, and it's a playground for lawyers, ultimately.
Well, Mr. Chairman, my intent on adding that additional element to the discussion in response to Representative Stiss' comments is, I feel like, just speaking for myself, I think it should be a high bar. Like, we're in a position now where we have one person who doesn't like Mr. McKay in the neighborhood, and all kinds of problems ensue. We need to raise that bar from my perspective. Like, this is the Regulatory Reduction Task Force. We need to be raising the bar by adding that additional language, in my my opinion, and based on what I've heard in the testimony here, is that could be an additional element that would further kind of weed out just people who are unhappy with, Mr. McKay's behavior in his neighborhood, and could bring a concrete and particularized harm before the decision makers to decide if this is a good or bad thing. So, I do think we need to go farther, that is the intent, to bring that additional element to the analysis, to make sure that we're really at the heart of the matter, addressing folks that have legitimate, concrete, particularized harm that is demonstrable. If it's too far for some, then I totally understand, but I think, I want this in the discussion, just so we can flush this out a little bit, to make sure that we're hitting that right place that can give our private property owners the ability to decide what's in the best interest of their property, and give that outlet, that safety valve for people that feel that they can demonstrate in this zone that they're being harmed, and then put that evidence before the decision makers for analysis.
Mr. Chairman, just so I'll know what I'm voting on. The current amendment after the phrase 500 feet says, and who can demonstrate a concrete and particularized harm. By putting the and in, then we apply it to everybody. I just want to make sure that's what's on the floor here. Thanks.
And so I do have a question on that, because we have an or on line 4. If you have an and after the next phrase, that doesn't incorporate the precedent, anything before the or. So I'm not, or does it? That's my question.
Mr. Chairman, I would defer to staff on that. I think it's somewhat unclear to me, but the 50% does, or the current 20% does seem to be intended to apply to the people within 140 feet. So it does seem to be that the intent of the language is to sort of disregard the disjunctive effect of that or.
I don't think you can disregard the or when it's in.
Well, Mr. Chairman, I just don't know what the 20% I think clearly refers to both the area of the lots included and those immediately adjacent. So that's all I mean by ignoring the disjunctive effect.
Okay. Does everyone understand what we're voting on?
Mr. Chairman?
Please.
Thank you. If I understand what the amendment aims to do, it adds another layer to the test that the governing body that has this question can consider the petition. So if indeed they've got the 500 feet covered and the 50%, they still have the layer of determining whether or not harm is being inflicted, and therefore can feel comfortable about supporting the development if indeed they don't believe that the harm is being inflicted. Is that fair?
Right. Who can answer that question?
Mr. Chairman, I'll weigh in on that. That's my intent. If we've gotten there in the language that's on the table right now, I'm not sure. I think, that's the concept of my motion, is to have exactly as Mr. Napier said, that additional test that before the governing body can even entertain this scenario, all those elements must be established in the application to even have this discussion. So the goal, again, as I mentioned, is to kind of make that pool of people impacted smaller as opposed to bigger, which would therefore give the property owner more freedom to do what they want in the exercise of, changes to their property going forward. That's the goal of this motion. If we've got it, if we've gotten it down just perfect, I'm not sure of that without having it in front of me, but I've seen conceptual motions made very often, and this might be a circumstance where we might need to work with staff to massage a little bit, but that is really the end goal and concept.
So the only thing that makes it smaller is the last phrase. Otherwise, it's large.
Correct.
So any further discussions on the amendment?
Mr. Chairman, thank you. A couple things. I don't know, since we met last, been having some great conversations in Albany County. They've established their 3,000 housing units short right now of where they need to be. You know, what is happening in the communities like Cheyenne and Laramie and Casper that I know well is they're looking at trying to get units built at a rate we haven't ever done in recent time. And we do have regulations that are slowing that down. So I do appreciate exactly what Ms. Delancey just said, and that is I'd like to send a message out there that this committee is really trying to raise the bar to allow for development to happen more quickly when it comes to housing. Because that lack of housing is constraining business growth. In Laramie, certainly, I think in Cheyenne, I think in Casper, people are recruiting companies that can't come here because they can't get housing for their executives to try to then hire Wyoming people when they get here. So we've got a really big issue. So just want to kind of note, you know, that's the scale we need housing built at. And that's why I think trying to do something that allows to send some message. And I frankly, my take on this is that this bill is the best message that we're going to get a chance to send out of this committee about how much we're going to do on this front. I hope we can figure something on timing, but that's tough. So then just coming back to this bill in particular and this amendment, to have an amendment to the regulations, the first line of this, you have a vote of the town council or the county commissioners to grant this amendment. So this isn't we are not allowing ADUs, but I can't build that ADU in my backyard on my second part of my double lot by right. As a property owner, I can't do that right now. I have to go to the city. They have to vote with a majority of the city council would have to vote to give me that. And then it's if my neighbors are going to try to block that effort by me. And that's what I think we're trying to fix here, is really send a message that if we're not gonna allow ADUs by right, okay, but let's make it that much easier when the city council agrees that I should build an ADU in a public vote that allows for public hearing. And so after a public vote, that my neighbors can't come in and squash the project that was approved twice publicly. So I just want to clarify kind of where we are in the process of actually getting something built when this applies. And if I'm off on that, let me know. But I do just hope we can send a big message here. And I think we've kind of got ourselves to a place with a bill that allows us to do that.
Okay, everyone comfortable with the language? Understands it. I just want to make sure everyone knows what they're voting on. All those in favor of the amendment, say aye.
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 No. That motion carries. As amended. Any other amendments?
Question on the bill?
Question being called. Roll call, please. As amended.
This is a roll call vote to forward 25 LSO 0085 version 4 zoning protest petition amendments as amended to the committee of the co-chairman's choosing. Senator Driscoll? Aye. Senator Jones? Aye. Senator Schuler? Aye. Representative Davis?
Aye.
Representative Stith?
Aye.
Representative Yin?
Aye.
Director Matthews?
Aye.
Director Parfit?
Aye.
Mr. Bebout?
Aye.
Ms. Delancey?
Aye.
Mr. Martin?
Aye.
Ms. Olson?
Aye.
Aye.
Mr. Napier?
Aye.
Mr. Malm?
Excused.
Co-Chairman Grew?
Aye.
Chairman Nicholas?
Aye. So Mr. McKay, nice job of bringing that thing home. That was fun. All right. So I'd like to ask the committee's pleasure on the next two bills and which one they would prefer to dive into or not dive into.
Mr. Chairman?
Oh, go ahead.
1 second, Wendy, go ahead.
Thank you, Mr. Chairman. As I said before, after looking at all three of them, and I do appreciate ALSO's memorandum that they prepared, kind of giving us a summary of each. Even though I started out leaning towards one, I really like this one, and I think this covers us. I really do. I'm not sure we need the other two, but that's just me talking, so I'm happy to go along with whatever the committee would like to do.
Mr. Chairman?
Go ahead, Cindy.
I too, I really felt differently at the beginning, but, really talking through this with the committee and, really in light of Mr. McKay's last comments, like I completely agree that we've come to a really good place on this bill. And although I was sympathetic with, Representative Ian's comments about maybe sending more things forward, I really think it might be in the interest to get behind something so we don't add additional confusion, especially knowing that we're going to have a lot of folks that are new to this topic and have not, really had the background and, continuity that we've had working on this issue for almost 2 years now. So maybe back to your comments originally about keeping it simple, this bill might be the best vehicle, I think, to do that. And with the unanimous support from the committee, that again sends a really strong signal to those that will be picking up this discussion that we've spent a lot of time on this. So I would perhaps, maybe with all due respect to those involved with the work related to these other two bill drafts, perhaps maybe we table them for now. And if there's a desire to pick them up, in the future, that there's already something out there that future decision makers could pick up if so desired.
Well, just to follow up on that, if we present more than one bill to a committee, they're going to say, which one do you want? And they're not going to work all the bills. So that's just the reality of what we can do as a task force and what the committees will do. So I would generally concur with those. I mean, on both of the next two bills, I probably have myself 4 or 5 or 6 amendments on each bill. And we could be here till noon or 5 o'clock on those two bills.
Mr. Chairman, I would not want to go that way. I think keeping it simple, driving home Mr. McKay's point, while at the same time staying in a stance where we're not going to be fighting with the county commission or the Wyoming Association of Municipalities, I think puts this committee in a pretty good way to bring this forward and make it a good recommendation.
So someone online was, or on the screen, Bob, was it you? No? Anybody else?
And Mr. Chairman, it was me, but it's already all been said, so I don't need to add anything other than I don't think we should do it.
Okay, well, I think Mr. Co-Chair, I think we'll just take that prerogative and let's do this. Let's take a 10-minute break and we'll come back and hit the next bill and we'll not review 2 and 3, okay? We'll stand in recess for 10 minutes. Hey, welcome back. Next, we are dealing with the timeline bills. There are 3 of them. In committee, I've had several folks come up to me and said, let's start with number 2. Is there any consensus on which one to start with other than number 2? If not, I think that will be the draft that we'll begin to work and have explained to us. So Talise, come on up. Which is 207, right?
Mr. Chairman, members of the task force, Talise Hanson, Staff Attorney LSO, presenting Bill Draft 25 LSO 207, version 0.2, Building Permit Timeline Requirements -2. Staff comment on page 1 and 2 notes that this draft is an updated version of 25 LSO 106, version 0.9 that the task force's working group considered at its working group meeting on August 12th. The staff comment notes that the timelines and date deadlines in this bill draft are intended as placeholders for the task force's consideration and review. Subsection A on pages 2 through 4 provides definitions. These definitions include building permit review, complete building permit application, and local government entity. Subsection B on page 4, lines 20 and 22, and page 5, lines 1 and 2, provides that it requires local government entities to complete their building permit application reviews in the most expeditious manner reasonably possible and in a manner that ensures public health, safety, morals, and the general welfare of the public. Subsection C on page 5, lines 4 through 19, requires local government entities to adopt rules and regulations to establish a schedule for each type of building permit issued by the local government entity. The schedule must describe the entire building permit approval process, including all steps required for approval and issuance of a building permit by the local government entity, and establish reasonable deadlines for each step in the building permit approval process. The deadlines required must include a final deadline for each type of building permit application to be approved or denied by the local government entity. Subsection D on page 5, lines 21 through 23, and page 6, lines 1 through 14, states that if a local government entity fails to meet the final deadline to approve or deny a complete building permit application established in the schedule, then the local government entity shall reduce the applicable applicant's building permit fee by 10% for each business day after the final deadline until the applicant's complete building permit application is approved or denied, unless one of the exceptions applies. The exceptions are listed on page 6, lines 7 through 14, to include the applicant and the local government entity agree in writing to an extension of the deadline, the delay is caused by the applicant, or the delay is caused by circumstances beyond the control of either the applicant or the local government entity. Subsection E on page 6, lines 16 through 19, provides that each 10% reduction of an applicant's building permit fee shall be based on the original amount of the applicant's building permit fee. Section 2 on page 6, lines 21 and 22, provides that this act shall apply to building permit applications filed on and after July 1st, 2025. Section 3 on page 7, lines 1 through 3, requires local government entities to publish a schedule required on or before July 1st, 2025. Section 4 on page 7, lines 5 through 13, provides a split effective date, with sections 1 and 2 being effective July 1st, 2025, and sections 3 and 4 being effective immediately. And I'll stand for any questions.
Okay, any questions for Talise on the draft? Any public comment on the draft? Welcome. Got 2 Jedi Knights up here now.
Good morning, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association. It's a pleasure to be with you this morning. I'll make comment on version 2, but may expand that to some of the other provisions. I do want to just express at the very front that we're favorable to trying to find some sort of timeline standard. It's just a matter of what that looks like and whether we can actually accomplish it on your behalf. First thing I'll say about all of these bills is that it would be helpful to focus what they actually apply to. And what I mean by that is that it'd be helpful if this focused on residential and perhaps more general commercial activities and perhaps not to more complex commercial and industrial activities. Some of those more complex elements require local governments to actually hire outside counsel, outside engineers and other staff in order to process those applications. And those things can take time and money and ultimately don't fit into a nice little box that some of the other activities might fall into. So giving a little bit more focus in that regard would be helpful.
So before you go on,
yeah,
do you have some suggestions for language?
Well, so Mr. Chairman, I think that you would insert something on page 2, line 19, that would perhaps, of course, have residential in there. I don't know that I'm the best person to suggest exactly what the commercial language would be, but there are certainly others that are smarter than I in order to accomplish that. But I think that's where ultimately that provision would go.
Yeah, go ahead.
Mr. Chairman, on page 2, and this is the provision, the definition for building permit that goes from page 2, lines 17 through 25 into page 3, 1 through 11. That definition incorporates many actions that certainly some of them are building permit related, but others that aren't necessarily building permit related or loosely associated. So one example would be utility reviews. I think tightening up that definition would be really helpful, and I think my colleague has some thoughts in terms of how to do that best. Mr. Chairman, moving on to page 4, this certainly isn't an affront at our state fire marshal, but I think that my colleagues at the local level are a little bit frustrated that this legislation just targets local governments. And the reality is that there are many local permits that are issued by the state of Wyoming, including the state fire marshal's office. So what's good for us ought to be good for the state. So would suggest that you look at broadening the application of this particular legislation if you're going to move forward with it. Finally, and this goes to the penalties provision, I think we're more of the mind that tell us what you want to accomplish and we're going to go do good for you. And we don't need to have these penalty provisions. But if you're inclined to keep those penalty provisions, maybe we can look at some alternative approach. And I'm even open to this more broadly. I've mentioned to some of you and in some of my comments in the past that there are other jurisdictions that have developed pre-approved ADUs, pre-approved building permits for residential units. I don't think my folks are opposed, those that actually have regulations in place are opposed to developing pre-approved plans so that if somebody is going to build to those specs, is willing to come in the door and say that's what they want, that it would be an automatic approval. So one concept would be that you would add that as another component of this legislation, that local governments would develop 1 or 2 pre-approved plans and in doing so might get themselves out of the penalty provisions of this particular legislation. It's just a concept, an idea to bring forward, trying to be productive in the conversation, but with that, Mr. Chairman, I'd be happy to stand for any questions, but would prefer this version of the timeline bills over the others.
Mr. Chairman. Go ahead.
Mr. Chairman, thank you. I think your idea is a great one. I really like the idea of your pre-approved plans. How could we get where those aren't poison pill plans? I can envision a couple plans getting put up that just don't work. And so consequently, no one ever uses them. How could we ensure that those pre-approved plans would be workable and usable? Because that idea, I think, is a brilliant part of being able to make this work, is for someone that's developing, if you can come in and say, look, if you meet this set of criteria, you're automatically in. So how could we be assured that a city's not gonna, or a county, put up 2 pre-approved plans that say the costs are gonna be ridiculous doing them? So yeah, we checked the box, but no, you can't really build to it because it doesn't work. Thank you.
Yeah, Mr. Chairman, President Driscoll, it's not a question I've thought a whole lot about, but I think that ultimately we just draft that into the consideration of what we're ultimately trying to get at here. I don't think my folks are interested in trying to drive towards things that are unattainable or frankly don't solve the problem here. We want to be a part of the solution. We've seen this happen in other jurisdictions. I brought it forward as an idea. The example that I used was that Summit County down and actually I think the city of Breckenridge, Colorado, have developed 3 pre-approved ADU approaches. Their sense being that they're trying to provide workforce housing, and that's one of their directives, is that it be used for that particular. I'm not saying we need to do that here, but that's the concept. I'll think on it a bit more, but I think ultimately it's just how we put together that statutory language and what we're trying to accomplish here.
Go ahead.
Mr. Chairman, Mr. Riemann, I've heard from some smaller communities, and they're saying that these deadlines that we might be imposing could possibly cause them to hire additional employees to meet this. Have you heard this from some of the other commissioners across the state?
Yeah, Mr. Chairman, Senator Jones, it's absolutely something that I'm hearing. It is more prevalent as you look at the other 2 pieces of legislation that are before you. Version 1 requiring the individual determination and schedule and the constant communication that imposes. That one is a bit more complicated. I'm hearing less of a concern about just having to post and ultimately try and adhere to those timelines. I'm not hearing the frustration over that particular approach, but it also extends into what I mentioned in terms of what this applies to. Does it just apply to residential and general commercial, or does it apply to these other things? For example, I heard from the city of Laramie, and they gave me, let's see if I have the numbers for you. In 2023, they had 1,656 building permits come before them, and that first version would have required individualized communication with each of those. That's time and money away from the actual job we want them to be doing. The other problem for them is that the University of Wyoming is building some very complex facilities on its campus, and that requires them to go get special expertise, likely outside of the state, and that takes them more time, again, that you can't fit into that box. So to answer your question fully, yes, I'm hearing concerns, less so with version 2 as opposed to the other 2.
Go ahead.
Thank you, Mr. Chairman, and Mr. Riemann, thank you so much for sharing those concerns. I just need to gently push back a little bit because, again, this is a discussion of this push and pull, trying to find the right balance for everybody involved, because as much harm or undue burden is being put, on the local governments, it's the same thing for the applicant that's having to hire additional engineers, lawyers, hydrologists. It's the same type of, it benefits everybody if we can find some kind of vehicle to address, to have a time frame that is expeditious for all the parties involved, because it's the same type of harm that you're articulating on behalf of the local government that the applicant is currently experiencing under our current process. So I'm just really, trying to be thoughtful in how we can try to minimize harm for all the parties involved in the process. And I think this bill is a really good start to doing that.
Go ahead, Wendy.
Thank you, Mr. Chairman. Also, Mr. Reman, I'm just kind of checking, since you kind of have some issues with some of the penalty provisions, I wonder if you have some recommendations in that area instead of what we have here in the bills.
Yeah, Mr. Chairman, Senator Schuler, obviously there's one easy one, that's to remove the penalty provisions. That would be preferable to us. What I'm suggesting is if you wanted to keep those penalty provisions, perhaps give an alternative approach, maybe a get out of jail free card, if you will. You can get away from these penalties if you do X, if you can develop these pre-approved approaches for single-family residential home, for ADUs, for what we want to accomplish here. It's just another approach if you wanted to keep them.
Further questions for Jeremiah? Go ahead.
Mr. Chairman, to speak to Mr. Ryman and the process of issuing permits under 359108, the state fire marshal does not notify the sender in writing of violations of fire electrical standards within 21 working days of the received plans. The approved as submitted, the code deficiencies are discovered through an inspection will be corrected. So the state fire marshal does, and the office does, process permits within 21 days. So as we look at that process, we have 21 days from the time we receive a permit to provide comment and correction. If we provide correction, that is the only items that we can speak to. To speak to the pre-designed plans or pre-approved type situations, the International Code Council does publish 2 standards for off-site manufactured housing, and that's standard 1200 and 1201, which gives us those predefined and ability to, per se, pre-approved. This is what it looks like. The only connections we would look at in 1200 and 1201 would be the electrical, plumbing, and utility connection. So whether that was gas or propane, what that looks like. So there is some option out there that other folks are using. There's a couple commonwealths on the East Coast that use those. And working in the executive branch, we have had some discussion with those offsite manufactured, and that is some of the discussion that's going on the west side of the state as well.
Mr. Chairman, Mr. Reman, can you walk us through, what if we just approved this bill draft as is, and it sails to the legislature, signed by the governor, becomes the law? How would this actually work in practice? Because as you noted, the building permit review definition is really broad. It seems to cover things that we don't just think of as building permits, right? Like if you have raw land, you want to create a subdivision, right? There's a whole process for that. And then on subsection Romanet 2, the complete building permit application appears to require that you have to have construction plans for the proposed work for the project. So if we actually adopted this, what would actually happen, if to the best you can predict?
Yeah, Mr. Chairman, Representative Stith, if it was adopted without any particular changes to this, counties are going to go about developing those schedules and making sure that they're adopted and posted beyond what they already do. Some of them likely have this arrangement in place. I think the issue in particular with the building permits is that you have the threat perhaps of some jurisdictions, yours being one that's expressed some concern about this, where they don't have particular permits that they author or offer in those particular areas, but now are they going to have to do something because of this particular legislation? And they wouldn't consider that a building permit. So it's going to cause some confusion and perhaps some additional regulation put in place that otherwise wouldn't in some of the jurisdictions. At least that's what I'm hearing from some of the planners as it relates to this legislation and that definition in particular. The other parts, I mean, the penalties are going to be the penalties. The application to local governments is going to be to local governments. I don't see anything else there that creates great concern. There may be some frustration in terms of those more complex building permits that I mentioned that are going to take more time in some jurisdictions, and they may not be able to adhere to a nice in-the-box definition of what that timeline is. But this gives us some flexibility to develop what that would look like, though.
Mr. Chairman, follow up? So, Mr. Riemann, on the penalty piece of it, let's imagine the application process is very delayed, all these penalties kick in, and now the net building permit fee is now 0. What impact will that have on whether the permit actually ever gets issued, if at all?
Mr. Chairman, I see nothing in the legislation that would demand that it's then issued. It would just be processed with no fee attached to it.
We can modify it so that you have to start paying the applicant.
So, Chairman, I ultimately don't think that's going to be the issue that we're dealing with.
Mr. Chairman, thank you. Jeremiah, do you think that local governments will raise permit fees in response to help make sure that they can meet those deadlines in the bill?
Mr. Chairman, Representative Yen, I don't know whether they would with this particular legislation. It's not my sense that they would. With other versions of the legislation before you, version 1 in particular, it's quite possible that that would be one reaction in order to be able to deal with the complexity of constant communication.
Further questions? Go ahead.
Sorry, if I may, one thing to consider on the remedy on permit fee is if permit fee is refunded or you reach that threshold, there also in a lot of jurisdictions are inspection fees because they're still going to inspect this property. They're still going to ensure that that project meets the intent of the code. So what the carve out might be there to do some of that offset is yeah, the permit fee may have that reduction, but you don't reduce the inspection fee because you do need those folks to actually go out and make sure that the project is and meets the intent of the code.
Good. Further questions? Bob, go ahead.
Yeah, Mr. Chairman, I guess my question would be, who is the oversight that enforces this legislation? I mean, what agency is in charge of making sure that this does get applied? Do we have an agency that would be the oversight over? Is my question, and with the complexity of these different issues that they're talking about as far as permitting and the different things that we're looking at over residential to commercial to special use to et cetera, what agency oversees this? Are we growing an agency to regulate it? That's my question.
Mr. Chairman, I'll take a crack at it. Representative Davis, it's my sense, just like 99% of the things that we deal with on a daily basis, the courts ultimately are going to be the ones that enforce this. I don't know that we need to grow a new agency here.
Well, in essence, I think the answer to that question is it's all self-regulated. So you just have to comply with statute. If you don't, then there's a recourse to the courts. But basically, it's self-regulated. Answer that question. Okay, any other questions for Jeremiah? Go ahead, Ryan.
Thanks, Mr. Chairman. At risk, Jeremiah lives within 500 feet of me, so just got to be real careful on this. But I guess in my mind, like what we're dealing with in this moment in time that I alluded to it in our last discussion is the housing market is changed so much over the last few years that I think everybody's trying to come to grips with this and also figure out how to be competitive when I think a lot of times we'd set up a situation to protect the existing landowners and now we have to try to figure out how we get homes built again. So, Mr. Riemann or Mr. McLaurin, my biggest question for you is kind of how do we encourage locals or have the conversation to help them be more competitive in running their governments and their offices to issue those permits, so that they're the most attractive places to build homes in the years to come. I see this, and as I understand it, to build off what you were saying, Representative Stith, is each municipality or county could set its own timeline. So, some schedule could come out and say, well, we'll issue that within a year. And if they don't, that's when the penalties kick in. That we would be leaving that autonomy to them. But I really hope, again, just to have this back and forth between the state and the local governments is ideally, this is just a moment in time when we're going to start to get as competitive as possible going forward. So I don't know if you have any comments on that to bring forward in this discussion, because I think that's what I'd like to really be a part of. And as Co-Chairman Guru said, this discussion is going to go on, because anything we do now may need to be tweaked next year as we try to do these things. But that's from where I sit is just trying to set up the Wyoming and its municipalities and counties to compete with Colorado, South Dakota, Montana, Idaho as the place to build. And especially because what we need are people to come in and build 200 units at a time. So do you have any thoughts on building that kind of culture into this conversation, whether it's this bill or somewhere else?
Go ahead.
Yeah, Mr. Chairman, Mr. McKay, I have started a poll locally. We're going to check. It's a great question, and I think the reality is at the county level, I can't speak to the municipal level, is that the planners that are there, and it's a changing culture. I think that we have new people coming in. They really are interested in pursuing these building permits, and they are actually issuing them in a very timely and expeditious manner. Do we have one or two jurisdictions that it may be a little bit slower? Sure, and maybe this particular legislation might force their hand a little bit. I doubt that. I think what I'm hearing more is that we need more tools in the toolbox in order to be able to advance some things. Laramie County needs additional access to water supplies in order to have smaller lot sizes and ultimately be able to do more. Although if you look at the county's actually issuing more building permit. There's more growth in the county than there is in the municipality in this particular area. So again, I think it's more about getting more tools to them and incentivizing some of those things rather than ultimately a bill like this. Are we opposed to this bill? No, we've come to the table and said we can make it better. But I think it's ultimately about tools.
Other questions? Jeremiah. Okay, Bob?
Well, in response to Mr. McKay's question, I mean, I think most of the cities are trying to do this. I mean, Lander, as my understanding, went through and tried to reduce lot sizes a few months ago. Cities want growth and development, most of them. There's occasional one or two that might slow things down, but I think the cities are doing that. A lot of the cities have ADUs as permitted uses in several of their zoning districts. So the planners, the city managers and the elected officials want growth and development for their cities. The other thing I would say, Mr. McKay, and something Senator Drew touched on about a year ago, is a lot of this is about organizational culture. And we create a culture of service. Not that the guy that walks to the counter gets everything he wants, but it's an attitude about you can't do it this way, but maybe we can do it this way. So it's not a set of regulations that's going to make this better, I don't believe. I think it'll maybe help, but it's going to be about creating a culture of service. And I think we have that in our cities. We have dedicated public servants They're working their behinds off trying to crank these permits out. There's a lot of pressure in the building permit office. So when I worked for a mayor for a lot of years in my last job, my first day on the job, he called me into his office and said, let me tell you something, son. We're here to serve the public. That's the first order of business. Not that they get everything they want, but you're here to help them, steer them in the right direction. So I'd say culture's a big piece of it.
Further questions for Jeremy? Go ahead.
Mr. Chairman, not necessarily a question for Jeremiah, but I think it's related to some of the testimony that we've heard. My neighbor over here, within 500 feet of me, might have some insight to this, but you know, what I consistently hear about like a bottleneck or a logjam or some of the barriers to development that Mr. McLaurin and Mr. Riemann have articulated from the local government is our adoption of international codes. Looking on the State Fire Marshal's website, as of June 28th, 2024, we now have 7 international codes that have been adopted in Wyoming. And I think that this is warrant and worthy of some kind of discussion in these permitting bills, because some of our international codes jam up this time frame and put the local governments in, you know, a conundrum. So I guess, like, for me, spending a lot of time listening to all the elected officials on this committee, I don't ever really recall having our elected officials adopting these 7 international codes that kind of get us in this bottleneck. Like, I think this is more of an executive branch function. And so maybe, since we have such talent and expertise on this committee, you know, Mr. Chairman, if there is time to hear on how these codes play into these timeframes, might help us further kind of find a way to get to an answer on some of these really difficult issues. I see Representative Stish shaking his head down there. So, you know, am I onto something, I guess, is my question.
Mr. Chairman,
Go ahead.
shaking my head in agreement, just saying.
Go ahead, Bob, response or?
Well, I guess, and I agree, Ms. Lance. I remember sitting in council meetings and the fire chief would come in and you have to adopt the 07, the latest building code. I think it's a question about liability for the lawyers. What kind of, and I'm not an attorney, but if you start deviating from standard building codes and fire codes, what kind of liability are you exposing the municipality and the state to? Would be the question that I would pose. That I don't disagree. It's been a source of a lot of frustration. You know, you have to sprinkler this because you've done 3 units instead of 2, and the fire code says this, and there's no exception. There are some variances in some of the codes, but I think that would be a question for the legal staff. How much exposure does this expose you to when you deviate from standard fire and building codes?
So just before we go too far down this rabbit hole, that's really not in front of this bill. And we could argue on that all day long, but, and have had a couple thousand different opinions on it. So any other questions for Bob or Jeremiah? You go ahead.
Mr. Chairman, quickly, in understanding the rabbit hole that we're walking along, the codes as adopted do not establish timelines. Timelines are left at the local level, excluding the fire marshals, which I spoke to in 359108.
Okay, further questions? Okay, any other public comments or testimony? Come on up, please. Welcome.
Not good too far.
Good morning, Melissa Ruth with WyoPass. I'm also a professional planner here in the state of Wyoming. WyoPass did submit a letter, WyoPass being the Wyoming Planning Association, did submit a letter regarding the 3 bills in front of you, looking at this one specifically, version 2. The first question that we have and our first comment is really we're unsure what issue this bill is trying to solve. As written, the definition of a building permit far exceeds what is typically understood as a building permit. Plat reviews, site plan reviews, subdivision review, transportation review, and zoning review are all covered under different state statutes. Zoning reviews have a specific timeframe that is required. Subdivision and plat reviews are also regulated by separate state statute, as well as the Wyoming Administrative Procedures Act. Utility review and electrical, mechanical, plumbing, sewer, and water, as have been mentioned, are typically or can be reviewed outside of a local government. So there's additional level of expertise that's required. We echo generally what has been said by other public comment about the bill specifically targeting local governments, because state agencies are not required to follow these. Regarding pre-approved plans, the work that I do is throughout the West, including Colorado and specifically in Summit County, and other communities that have pre-approved plans. Sometimes they work, sometimes they don't. Part of it comes down to staff capacity. That's the biggest question and the biggest comment we have regarding these bills is with these timeframes, or in this case, there is no timeframe specifically set in this bill. Is it actually reducing regulation, or are we adding another layer of regulation in this case? Most communities, regarding building permits, if we look at the strict definition of building permit, which is what would require a construction plan and the review, the inspections, those sorts of things, those are being approved or reviewed or commented on fairly expeditiously. The permits that take longer are the permits that are more complex. Zoning reviews, subdivision plats, all of the things that are included within this definition of a building permit are the things that are taking longer, typically for good reason. There's additional reviews that need to occur, there's additional expertise that has to be found. You're contracting engineers, you're contracting other folks in order to help you pull together these applications. If the goal of this commission is to build housing, I don't know that this bill does that. I'll stand for any questions.
Mr. Chairman. Ma'am, I just wanted to reiterate what you said. So you're thinking we are grouping together a bunch of things that aren't similar and we're kind of putting them under the same umbrella and possibly creating damage instead of trying to do good here?
Chair, through you, yes.
Questions for, I'm sorry, I forgot your name.
Melissa Ruth.
Ruth or?
Ruth, R-U-T-H.
It's like babe.
It is.
Questions from Ms. Ruth? Go ahead.
Ms. Ruth. So what I just heard you say, I just want to make sure I got it. So right now, the bill draft that we're looking at, you feel is too broad, trying to go in too many different directions. So would it be fair to say that if we narrow that scope down to vertical construction, if you were just saying when you're coming in for a permit to do your construction of your building permit, that in that time frame, putting a time frame on that, if you're trying to get housing, I guess my point is when people come into a planning office, most of the time they're coming to get a building permit for a single family home. All that other stuff is done by other groups of folks that is more narrow in scope. But just the rank and file folks coming in, a bill to try to get them get the community into a time frame to get those permits out. As you said, when it comes down to that permit, it usually happens expeditiously. If we narrowed the scope of that, would that be something that you think that might help communities that have a harder time with that get there? Would that be a characterization of what you're saying?
Mr. Chair, it's hard to provide specific comment without seeing it, but there are other states that have created and drafted bills to that effect. Most recently, the state of Utah has approved a legislative bill that requires residential building permits to be approved. I think it's within 30 days. And if you can't do that, or you can't, you have to provide reason as to why. That is from following this bill from kind of the first discussions, that's where we as an organization kind of thought that this was going. So the scope of this bill for this draft was far greater than what you see in other communities that are tackling housing, that are addressing some of the same issues that this state is. So in our opinion, the narrowing of the scope to focus on residential construction or a specific size of building, things like that, that focus on more streamlined and focused permitting processes is going to fare better as far as looking to get actual housing constructed.
Okay, thank you. So now if we could do that, if we could thread that needle, and we provided that and then put that out to communities, and then with the expectation and stated expectation, but not necessarily written into law, but a stated expectation about something else that's discussed here a lot about coming forth with pre-approved plans. So if you say, we want you to be in this 30-day window on vertical construction, trying to get communities, and I'm asking if by doing it we could get there, is to get communities then to come back and say, hey, we got an idea. We can do this faster. If we showed you, general public, these are 3 plans, like for an ARU or ADU, whatever you call it, that would be pre-approved, just try to steer them in that direction. Then inside that 30-day frame, communities would know, planners would know, if we provide these plans, then we know we're gonna get something that we can knock out of the park every time. Does that cause and effect happen? Have you seen that in other communities, or do we need to do some other step?
Mr. Chair, pre-approved building plans are kind of a newer conversation as far as in the planning realm. Most commonly, they focus on ADUs, accessory dwelling units, because they are a little more straightforward. Single family and multifamily residential, there are communities that have done that. I don't know, again, to the success that they have been used, because part of, like if you look at a large subdivision, there are communities that do require variation in architectural style or layout. And there has been concern, as I've worked through codes with other communities in pulling pre-approved building plans for single family and multifamily residential structures, that you will end up with the same house everywhere throughout the community. Maybe not a bad thing, but something to consider, especially if you look down to some of our most southern communities. Wellington is one of those communities that got a lot of structures that look exactly the same, and you can see it off of the side of the highway. So something to consider, but mostly it's being done successfully with accessory dwelling units.
Mr. Chairman, following up on Senator Gru's comments, Ms. Ruth, if on page 2 of this bill where we have the definition of building permit review, if you added on line 19 the term residential in front of building permit, so that it would read building permit review means all reviews and appraisals required by a local government entity to approve and issue a residential building permit, period, and then you deleted the rest of the definition, would that address your concerns? I mean, it would drastically narrow what this bill does, but would it address the concerns that you've raised?
Mr. Chair, yes, I think it does address a number of the concerns that we have and falls in line with what other communities have done if we're looking to, or other states have done if we're looking to be competitive with other states as far as the housing market.
Good, Wendy.
Thank you, Mr. Chairman. Just for curiosity's sake, you worked with other states, and I'm wondering kind of what is typical, like in Utah or Colorado or some of these other states around us, for being able to get out a building permit. Is it 30 days? Is it less than? Is it more than? I mean, what's the ballpark figure for that?
Chair, Senator Schuler, it depends. I would say in most communities that I have worked in, residential type structures, single family residentials, ADU, can typically be done in under 180 days, so 3 months or less. Again, depending on how big the structure is, what your zoning is, if you've got other reviews that need to occur at a state level or connection, like if you need water, sewer, if you're in a city, you need to get that connection approved. The other commercial, industrial reviews, it's really hard to say because it kind of depends on the structure. Large-scale industrial is going to take a lot longer than like a retail shop or something like that.
Thank you. I appreciate that. I was more concerned with residential, so thanks for answering that.
Mr. Chairman, if we were to change that to residential, do you still feel like some of these other items need to be taken out? Are we still lumping a bunch of things together that maybe we don't want? I think the goal is to try to streamline something so we can spear residential growth across the state, and that's our goal. Build houses and get people to live here for their lives. So if you have any suggestions.
Chair, Senator Jones, I think this suggestion from Representative Stiff to add residential and then put the period after building permit and remove the rest of those pieces is probably the simplest, most expeditious way to address specifically residential construction. Again, the other types of permits there are state statute requirements as far as timing. Plats have to be approved. There's certain hearing requirements, and subdivision plats do have to go through public hearings. So you're looking at review times and public hearings, and it's not just an administrative and staff review, it's a elected official review. Same with zoning reviews. So I would strongly recommend removing, lines 21 through page 2, lines 21 through page 312, so all of the subsections A through G, because that residential building permit statement is going to cover pieces that are not already covered by legislation.
Further comments or questions?
Thanks, Mr. Chairman. But just wanted to follow up because, again, I think there's an interesting distinction on the permitting that Director Matthews' agency does. They are required to do it in 21 days, and you have counties that opt out of doing that, allowing the state to do it, and then they're not subject to that 21-day review. So they could just turn that back over to the state and be under the 21-day review, and we'd have that certainty for people who want to develop here, because there isn't a 21-day review requirement for the counties that opt to do that on their own. So interested if you wanted to follow up on your comment about the differentiation between state and local, because that's one where the state does have a very clear deadline and the locals don't. So the locals, if they don't like the deadline, could just turn that work over to Director Matthews' agency again if they want. And then to question to you about timing, Senator Shula asked you about other states. What's going on in Wyoming? Do you know kind of generally the scope of it? Is it transparent enough? And do we have tools around the state that allow a developer to come in and ask and say, how long will this take? How long does the average take? Could you provide this committee or a future committee with examples of I think our friends in Teton County have a website that tracks permits. So are there examples of websites that show timing and where a permit is in process in Wyoming? Or can you provide certainty today to a developer to say, if they walk into an individual municipality with what the averages are? And can you provide that by county or municipality or an average?
Chair, regarding the state review, the fire marshal review for 21 days, specific, from what I understand, it's specific to the state fire code. It does not relate to your on-site zoning. So if you have specific setbacks within a property that are for, like from a road or from other structures, it's not going to look at things like that. And please correct me if I'm incorrect. There are also a number of communities, specifically counties, that do not have building codes. They do not have a building department. They are one person, and that person might not even be a planner. That person might wear 3 or 4 different hats. It might be your treasurer and your planner and your engineer and your insert name of other official here. Those sorts of communities are the ones that have, and I think WCCA did mention this, that they're the ones that have more questions about when this comes in. Do they then have to adopt those codes? What are their guidelines for approval of permits if they don't even have a permit process now? The communities that do have building permit timelines, you mentioned Teton County. Teton County does have a website, an application portal where you can see exactly where a permit is in process. It's a little harder if you are not the applicant to see where that permit is, but if you, for example, search a property, you can see exactly what permits have been pulled, where they are in the process, when they were approved, denied, and why. Not every community has that because that sort of a web portal is expensive. But from the conversations that we've had as a board, and I don't have a specific number off the top of my head, but I'm happy to work with WAM and WCCA to pull that information for each community. Most communities are approving building permits, again, if they're complete and therefore a residential structure, within 3 or 4 months. Some might be faster, some might be a little later, but they're not taking 6, 8, 12, 24 months, as long as your permit is complete, from my understanding. I haven't received a text from any community yet, but I'm wrong, but I might be. But that's typical. Again, the permits that take longer are those longer permits, or those permits that have more complex issues. We're dealing with subdivision, zoning, things like that. So if you have a zone change that you need to do in order to get that residential permit, if that's being rolled into your overall building permit timeline, then yeah, you're gonna be looking at a longer timeline. But from when you have the ability to submit a building permit to when that's approved, those are far shorter timelines than I think what might have been said earlier. Does that answer your question?
So I do have a question on page 3, where you're talking about site plan reviews, subdivision reviews, zoning reviews. You say that those are controlled by statute. What we have had testimony in the prior meetings that in fact they're not controlled by statute. Sometimes it takes 3 or 4 or 5 years, or sometimes the county just doesn't take it up or make a decision on it. So it sits in limbo. So essentially what this bill tries to do is capture each of those in such a way that it's done expediently, but it's done, right? But you're right, because we're kind of lumping everything into the same stocking, and they don't fit all together. So we want to have those things done expeditiously and timely, based upon their sophistication and size and how much time it takes to review and actually make a decision. But we want that decisions to be made and be made promptly to expedite the process, whether it's a new subdivision plat or just a site review of a vacant property. I mean, it's obviously clearly different things. So what's your suggestion on how to accomplish that? How can you help us, planners?
Chair, for subdivision reviews, there are statutes that require public hearings for subdivision reviews. Subdivision reviews are required to be approved by Board of County Commissioners in a county. And that's just because I have the county statutes off the top of my head right now. In my work as a land use code specialist, I draft land use codes for counties throughout the West in my profession. So speaking from a personal, professional stance here, we strongly recommend that each community, when they draft their land use code, does include some form of information about what the permitting timeframes are for applications. So how many days does it take to get to a planning commission review, to a Board of County Commissioners review, staff review? Teton County and Town of Jackson have specific flowcharts within their legislation or in their regulations that actually lay out the timeline for each application process. That's not required by statute, But if you're looking to require a specific time frame, I would say that that is something that's practice, even across the West, to have some form of kind of information about how long does it take to get a permit through the process, whether that's a flow chart or a set number of days. I don't recommend codifying that because each community is different. If you have a really small community, say Pine Bluffs, versus the city of Cheyenne, those are very different processes. And you also have a different level of expertise. Again, Pine Bluffs doesn't have a planner, but they have zoning. And their zoning is very short. I think their whole zoning set of regulations is like 12 pages. So when you're looking at different communities, I think it's really important to think about the level, when you have professional planners like myself and like our board and our members, we do work closely with our elected officials, with the community, to understand what's going to work best for the community. And it's difficult to provide a specific number of days. Again, it's kind of a range and it depends on the complexity of the application. But if you were looking to specifically require a number of days, I would recommend that the community you require that the community publish some form of here's how long processes typically take, but having that be a hard deadline is difficult because you don't always know what's going to come up. But I wouldn't lump them all into one bill under a building permit because that does cause confusion. I mean, if you have a new planner coming in and they're looking for building permit, I would say most planners are not going to understand that A through G in the subsection are all considered building permits. That's not best practice.
Mr. Chairman.
Please go ahead.
Ms. Ruth, following up on that, so are you saying you think that Teton County, for timeline of processing applications, has a best practice? I mean, some of the testimony we heard would indicate that there are substantial delays that have occurred and measured not in weeks or months, but in years.
Chairman, Teton County is always a tough one. But I did in a previous life work in Teton County as a development consultant. And it was, in my experience, always very clear what the process was, how long it was going to take if you did things that were expected of you. If you sent in a complete application, paid your fees, and your application was determined to complete, it was very clear what the process was. You were handed a schedule of here's when your hearing is, here's when all of these things come through, here's when comments are due back from other agencies. I would say that's pretty common even across other states. So a lot of the work I do most recently is in Colorado, and a lot of communities in Colorado, Utah, Idaho, Montana all do something similar where they send out just a general timeline and here's how long the process typically takes. But again, if you have an incomplete application or you've got an unusually complex application or an application that requires something like a rezone or a subdivision permit, or you have CC&Rs or something like that, that is going to lengthen your process, and that's not necessarily the fault of the local government.
So what happens if you have a local government, whether it's a county or city, that has essentially a no-growth policy? Then how do you, as a personal property owner, landowner, say, I want to build on my property? And so how do you balance out those two issues?
Chair, I think you're asking a question that a lot of communities are grappling with right now, especially in the light of water as the biggest conversation. I don't know that I have a good answer for you because each community is different. Most of the communities that I can think of, if they have a no growth policy or a no growth in specific areas, it's for a good reason. It's because there isn't water, or there is a septic issue, or you've got a 30% slope and that's expensive to build on, or you don't want to cause a landslide, or you're in a floodplain, myriad other things that are more hazard to life and property. But I think you're asking kind of an important question, but I don't know that this bill can address that. That's kind of, it's something that...
But that's what this bill is trying to do, in essence, is define a structure, require reasonable decisions in a reasonable amount of time so that people can build economically on their property. And have it inform a system that says, if you don't, then you're not following the law. Anyway, it's a dilemma. I mean, I understand, and I appreciate your testimony, and everything you say makes sense. So,
Wish I had a better answer for you, but I think it's the same conversation we're trying to have. But I think the thing to keep in mind is that the planners and local governments are not trying to make the process harder in most cases. Most planners that I've had the pleasure of working with are trying to help folks. They're trying to work through the process, trying to help applicants kind of understand and navigate the process. In my experience, I haven't worked with every community, so there's probably someone out there, but they're not trying to hide the process or make things more difficult than necessary. They're trying to help folks through the process and help them understand what they can and can't do.
and so are we. Go ahead.
Thank you, Mr. Chairman. So when you have a state that has, as you testified, you've got one community that has guidelines and can hand you flow charts and how long a process takes for this, to another community that has all their zoning regulations in total don't add up to probably the one community's flow chart. Would it be fair to say, if we want to try to get to, and what Mr. McLaurin, the Jedi Master, talked about, is get to that culture? So starting in that narrow focus and then try to move towards the day that we have that across the board would probably be the best way to start that process, wouldn't it? Would you agree with that?
Chairman, I would say having a more narrow focus is a good place to start, yes, because it allows you to see how the process works and then adjust as needed. Whereas if you start with a broader process or a broader bill, you may find that there are multiple other problems that you create. But if you're focused on residential building permits, again, like other states have, you can kind of start to see how that's working for them and what issues are coming up. And I'm happy to provide the other bills that other states have looked at. Again, Utah, I think Montana, maybe Nevada. There's another state that just did this, but there are other states looking at this, looking again specifically at residential building permits, residential structure construction.
So I'm looking at LSO. This draft bill is, I think, a combination of the Utah statutes and a couple other ones that we've kind of stacked, kind of combined. At least, where did this come from? I'm trying to remember the back.
Mr. Chairman, the penalties in that part is from the Florida statute, and then the other parts were kind of a mix of just what you guys wanted, and the Utah statute just narrows it to single-family residence and has that specific timeline for that. So this one's more broad, just saying that they have to have a schedule. Some of the other states narrow it and say that you have a timeline for this, and this is the timeline in their statute. They don't allow them to have a schedule or decide for themselves what the timeline is.
Okay, go ahead.
Thank you, Mr. Chairman. Thank you for being here. It's really been interesting to listen to all the different thoughts on this fascinating issue. And where I think that there's a lot of commonality is that planners, local governments, developers want an understanding of a time frame. And I've heard you say a couple times in relating to this bill, a complete application. And that's the point where I think we get sort of in this rat race, because an applicant turns in an application, the local government doesn't deem it complete, the applicant addresses the deficiencies, then when it's turned in again, there's new deficiencies identified. So we're right back at Groundhog's Day to go back to, do you think that this bill, whether we lump it together or not, Would this bill be improved, in your opinion, if we put some kind of language, very much like the fire marshal has to do in his statutes, that you get one bite at the apple as far as a plan review, and that the applicant therefore is put on notice of what the deficiencies are, and then has a time frame to fix those deficiencies, as opposed to, you've identified, I have a deficiency in my application, I come back, I bring you the completed deficiency, only to be met with a list of 10 more deficiencies that have been identified since that. Would that help if we tightened up, that ability for plan review to just address the deficiency once?
Chair, it might. In my experience drafting codes with various communities, especially across Wyoming, one of the things that is happening in order to, and I don't know that it's happening with building permits, because I haven't really worked on a lot of building permit regulations recently, but with some of the zoning and subdivision permits, is applications are not officially deemed complete under every set of regulations. Not every community has a hard, complete application timeline. And so applications in some cases are maybe coming through, and then as they go to the planning commission or the board, there's additional information that's requested. That doesn't necessarily mean the application wasn't complete, but as the board and planning commission are reviewing applications, they have additional questions. So I've seen it more with that issue of kind of running the rat race with the more complex applications. I can't speak specifically to building permits, since in my experience and in my opinion, the application form and what's required is pretty clear. But I can review that with the rest of our board and our members to see if there's other communities that have that specific problem with building permits.
Thank you. I just raise it because in this bill draft, there is a definition of complete building permit application. And whether it's, building permit, subdivision, I just think if we could figure out a way to minimize that, whether it's real or perceived by the applicant, this moving of the goalposts, sort of shooting at a moving target, that's where this level of frustration, I think, just exponentially increases for all parties involved. And so, again, we've seen statutory language in our statutes that prevent that moving of the goalpost. In our fire marshal statutes, it's 35.9.108C, 108C. And, I just kind of asked, do you think something like that, would that be an enhancement from a planner's perspective if this bill draft does move forward? Is this something perhaps that we should consider as a mechanism to kind of keep that time frame, whatever it is in the local jurisdiction, moving forward with, as a mechanism to avoid this, as I say, shooting at a moving target? Would that be helpful, I guess, is my question.
Chairman, I think having a number may be helpful, but it's important to think about what that number is, because again, some communities don't have multiple staff on hand. Some communities have multiple planners on staff, and others have none, or one that is multiple folks. So it's not something that I haven't seen, but it's something that if you're going to add a specific number of days that the application needs to be deemed complete, something to think very hard about what that number is, and if it's going to add burden on the local government. And as I think it was Bob said, take them away from doing other things that we do want them to do. There's something I was gonna say. There is, I believe, in the subdivision portion of the statutes, and I don't have that reference directly in front of me, there are specific timeframes for when an application must go through specific processes. So there is precedence for that, but I think those timeframes are longer, and same with, if you look at wind and solar, those sections of 18.503, I think there are specific procedural timeframes there. So it's not something that isn't in the regulations, it's just only in a few places.
Mr. Chairman, in response to Ms. Delancey, I mean, typically what happens is you have a checklist. I wouldn't put a checklist in the statute, but the statute should have a checklist. What's required for a complete building permit? The application. the site plan, the grading plan. How are you gonna grade the site? Are you gonna drain it into the street? You gonna drain it into your neighbor's basement? You know, how are you gonna deal with the stormwater? But the checklist would say, if you checked every box, the application should be complete. But I wouldn't put that in the statute.
Mr. Chairman, Mr. McLaurin, just by way of clarification, it certainly wasn't my suggestion to put the checklist in the statute for one size fits all. What my kind of thought process is here is that we craft some language analogous to the timeframes and the parameters that the State Fire Marshal's office does. And let me just, it's just 2 sentences, so it's really simple and easy. Plans which are disapproved may be corrected and resubmitted, period. The State Fire Marshal shall review only the corrections made in response to the violations cited in the initial review. If the State Fire Marshal does not notify the sender in writing of violations of the fire and electrical safety standards within 10 working days of receiving the corrected plans, they are approved as resubmitted. So that is just a stopgap of this perpetual, okay, we addressed stormwater, now we're dealing with noise, now we're dealing with view shed.
One bite at the apple.
Exactly. That's really, like, we've seen this in our statutes. So that was kind of my question to the planners, is would having this one bite at the apple language help us stay on track, but also provide a mechanism of fairness for all parties involved?
Agreed.
Mr. Chairman, I have a question for the fire marshal then. I just heard that, but you have 21 days to do a permit. And if you do it and there's a deficiency and you take the 21 days, if you find another deficiency, does that kick another 21 days? Or is that, do you just have that one bite at the apple that I just heard about?
Mr. Chair, to answer the question, as I understand it, I have a bite at the apple. Now, we're going to express that, hey, obviously we found this. If the submittal had a correction, we would take that 21 day. We've only got 10 days at that point on the correction. So we had 21 on the big plan, 10 on a correction. If we found a correction to the correction, 10.
Look at that. Thank you, Mr. Chairman. Thank you.
So we've got to, so we can move forward, someone needs to move the bill.
Move the bill.
Or not.
Move the bill.
Moved and seconded.
Second.
Please proceed.
Mr. Chairman, so right now, I think there's a tension between A Romanet 1, Romanet that starts on page 2, line 17, with this building permit review definition. There's a tension between that definition and then the definition that appears on the next page in A Romanet 2, complete building permit application. So there are 2 ways to resolve it. One would be to, just really narrow the scope of the bill and make it residential permits only. That would be one way to do it. But I wanted to propose a different amendment. Instead of so drastically narrowing the bill, the proposed amendment would be on page 3. And on line 17, after governmental entity, it would say governmental entity for such application, comma, which may include but not be limited to. That would be the only change. If I can get a second, I can explain.
Second.
Thank you. So, Mr. Chairman, so the purpose of this is to at least make this bill coherent, right? Because right now what's odd about it is that Romanet 1 building permit review definition includes subdivisions, right? But then Romanet 2 requires that to have a complete application, you have to have, construction plans for the proposed work for the project, which could be not just the subdivision, but in fact, anything you want to build on it. So I think adding these few words keeps the breadth of it without creating any disconnect between the two. So it's kind of a small change, just more of a cleanup. Doesn't really change, I think, what the intent of the bill is. It still has the disadvantage of leaving, well, advantage or disadvantage, as the case may be, of leaving this really broad, so it's still going to apply to everything.
Discussion on the amendment.
Mr. Chairman, could you restate that? Again, I didn't catch all of it.
Sure, it would be page 3, line 17. After the phrase government entity, it would say, for such application, which may include but not be limited to. So the idea there is just to recognize that there are different kinds of applications. You might have an application to create a subdivision, which is really different from your application to build 10 houses, right? And it's just saying that for an application to be complete, it just has to be complete with respect to whatever you're trying to do. Maybe that's already implied, but just wanted to clean that up so it doesn't create ambiguity.
Go ahead.
Mr. Chairman, to muddy the amendment, my apologies. Maybe the definition is creating, or the solution, excuse me, is to create a definition that talks about a site plan review. Because I think what we heard in testimony, and I think what we've experienced in some of these discussions is we have the first portion of the process, which could be clearly defined as that site plan review, and then the next being that building permit review. So we have kind of two processes that you have to have one to do the other, but they both go together to get the completed project. And just a thought on an opportunity there.
So committee, go ahead. Mr. Napier.
Thank you, Mr. Chairman. I'm kind of disappointed that we didn't get to hear testimony from WHAM, just to put that out there on this bill. But I want to understand the amendment a little better while we're on this conversation. If indeed we're talking about sort of honing in on the definition for a complete building permit application, can the amendment consider removing the previous list in Romanet 1 or I on line 7, starting with line 17, and focusing solely on Romanet 2 instead as the nature of this bill?
So committee, I do have a potential suggestion. Because I would concur with the testimony so far that having a site plan review, a subdivision review, and a zoning review in a bill that's called Building Permit Timeline Requirements is not cohesive, right? What we really need to do is have a structure where we set up a building plan review, and then in a separate section, address site plan reviews, in a separate section, address zoning reviews, and break it down into each category so it's in and of itself. And I think that that's part of Jeremiah's original testimony, is that we're doing too many things with the verbiage and not addressing, and because of that, it's convoluted, and the bill as it's currently drafted doesn't make sense. So I think that what I would suggest is that we take the testimony that we've heard, revise this bill so that it's broken down into those components, and the components make sense, and probably provide a draft copy to the planners who are interested in assisting us in doing this, so that we cover the bases and have something that is cohesive and simple. Either that, or we just take this, make it just for residential housing, and then have a second bill to come back and address it at some other point in time. I mean, those are, to me, those are the two options we have in front of us. So I leave that suggestion out in front of this committee just for purpose of the conversation.
And Mr. Chairman, I agree, and so I would withdraw my proposed amendment to Romanet A2.
So what about what I just suggested? What's the committee's feedback?
Well, Mr. Chairman, I think that's a good idea. I would propose an amendment to salvage something of this bill is to go the other way of resolving the conflict. I would propose as an amendment on page 2, line 19, inserting the word residential before building permit, putting a period, and then deleting the remainder of that definition through page 3, line 12.
So I believe we have a draft amendment that basically does that. Yeah. Oh. So I think what we ought to do is take some time to review the draft amendment, if that's what we want to do, and have it just address residential construction. And then this committee can do a couple different things. We can make a recommendation along with any bills we put forward that this is what needs to happen next we can actually get LSO to start drafting on it and to address the site plan, subdivision reviews, and the like, so that essentially working on two different drafts, a new draft in addition to this. That's probably the simplest thing, so we can actually move forward on the residential side today. So on this draft,
Mr. Chairman, that proposed amendment does not limit it to, doesn't specifically say residential, but you could add that in. It just said,
but it also removes a lot of the language we're talking about.
Yes, Mr. Chairman, it does.
So committee, thoughts on that? Wendy, go ahead.
Thank you, Mr. Chairman. No, I think you're headed in the right direction. That's where I'm at. I think when we look at our state, we're really concerned about building homes. And, the subdivisions, yes, in some of the bigger cities, but in some of our smaller towns, it's just, we need some homes built. So I think by focusing on just the residential building permit makes a lot of sense, and how we take a bite out of the others later on, I'm fine with. So I think it's a good suggestion.
So Talise, what would it take to modify this to do that?
Mr. Chairman, so you want to just limit this to residential, to apply only to residential building permits, and then have something separate that applies to the site plan, subdivision, zoning reviews?
Yeah, and so what I'm asking is, for example, over the lunch hour, can we tinker with this so that after lunch we can have a concept bill, kind of half drafted, you're just condensing it down into a residential construction. So that
Mr. Chairman, I could amend this to only apply to residential building permits over the lunch.
Yeah, I think that would be fairly simple. And I can help you do it, or do it.
I can do it, Mr. Chairman.
Buy a lunch. He wants you to, she wants you to buy a lunch.
Mr. Chairman, do you
Do you need an amendment do you need a motion for that amendment?
Yeah, I think that would be appropriate.
Okay, so moved.
Second.
All those in favor say aye.
Aye.
That motion carries. Happy lunch hour. Okay. And then the next motion is, or concept, and I'll propose this to the committee, is that what we'd like to do is have a similar bill, but it's only addressing site plan reviews, and then separately subdivision reviews and zoning reviews. and refer to the statutes that exist and as they exist, and how we would tweak those to create timelines to essentially create a structure so that for each one of those events, there's a mechanism that directs counties or cities or state to fit within a designated time period to provide those functions.
So moved.
Moved and seconded. All those in favor say aye.
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 That motion carries. Okay.
Mr. Chairman, one more motion for the committee's consideration. Since we're in the mood to motion and make motions, I would really like to see if Talise could work, this one bite at the apple concept into this language, just, modeled after 35.9.108C, which says, when we're working on those timeframes, that is the period. And then when the deficiencies are addressed in the site plan and the permit application, that they can only work off of those things that are identified and then have additional time once the corrections come back. But I think this one bite at the apple concept will help prevent the hamster wheel for everybody that they feel like they're on. And to maybe just have to take a look at some language as a starting point for conversation, perhaps.
Okay. Anyone comments on that proposal?
Mr. Chairman.
Are we in agreement or disagreement? Go ahead. Discussion.
Mr. Chairman, thank you. Yeah, I think it's a great idea, and I think we should, but my question is, with that and with the last motion we just passed, what's our time frame? I mean, I know we just directed staff to work over the lunch hour to reconfigure this bill.
That's just on the residential.
But that's just on the residential, but those other two are in the future, at a future meeting. Okay, I just want to make sure I had the timing right on how we were doing that. We need a timeline though for that. Just kidding.
Let's go back to the motion. I would say yes. And what we can do is just have that language available, because it'll kind of plop into every one of them. So as we review it, we can consider it with a draft bill. That just makes sense. So.
And Mr. Chairman, I'm happy to work on developing some language as well, to help to take the load off of the team here. I just think it's important to, come with something on this.
Okay, with that, let's take about a 5-minute break. It's 11:21. Committee, we can try to do those quickly, but let's just kind of reorganize our brains and then we'll come back. We might do the stairwell first and then we'll do the mitigation last, just so people know. That's that. Okay, we'll take a short break.
Good morning.
Okay, next bill up, we're going to go to the multifamily dwelling stairwell bill draft. Come on up, David.
Are you ready?
Please.
Thank you, Mr. Chairman. David Hopkins with the Legislative Service Office, taking a look at 25 LSO 250, Working Draft 0.4, multifamily dwelling single stairwell exits. This bill comes before the committee from a request at the last meeting to take a look at allowing for single stairwell exits in multifamily, multi-story dwelling units. And so just a little bit more on that then. There does not appear to be a statute that regulates for the private multifamily dwellings that is generally done at the local level. And in looking at that, it seems to be fairly common that local, for example, many municipalities have adopted kind of international standards, particularly the International Building Code, which does prohibit a multifamily or a single exit from multi-stories above, I believe, 3 levels. So what this draft does is provides then on page 2, it does create a statute then that except as otherwise provided and notwithstanding any other law to the contrary, no state agency, county, city, or town shall require more than one exit to serve 6 or fewer stories of a residential group R2 occupancy. And then it provides a definition for that residential group R2 occupancy, and this is consistent with the International Building Code definition, that it's a residential occupancy containing sleeping units or more than 2 dwelling units where the occupants are primarily permanent in nature and including apartment houses, boarding houses, convents, dormitories, and work units. Now, the IBC definition contains a few more items, and certainly it's up to the committee as far as what to specifically include in that list. But that's what the bill draft currently provides for. So then it restricts state agencies, counties, cities, or towns from acquiring more than one exit, except as provided in B, which we get to now, provides that a county, city, or town may adopt an ordinance or resolution requiring more than one exit to 6 or fewer stories of a residential group R2 occupancy, provided that the adoption of a uniform code such as the International Building Code shall not be deemed to prohibit one exit unless, in addition to adopting that uniform code, the ordinance expressly requires more than one exit to serve 6 or fewer stories of a residential group R2 occupancy. So the draft would not prohibit, local government from requiring more than one exit, but they would have to expressly provide for that in their ordinances. And that is what the bill provides for. Stand for any questions.
So what I'd like to do is to turn it over to Representative Yin. What's the real purpose of doing this, and what are we achieving by this bill?
Sure, Mr. Chairman. So I sent an email to the entire Regulatory Reduction Task Force. It has a link, but it also has this nice graphic of the building heights for single staircase buildings across the world. United States has one of the shortest requirements at 3 stories, and so that's in the International Building Code, which basically every municipality adopts. My desire was trying to find something where we wouldn't reduce safety while reducing regulations that could incentivize more housing, right? And so for essentially single small lots, you're never going to be able to build above 3 stories because you're never going to be able to build a corridor that has 2 exits and still have space for actually multiple units on a floor. So if you go to Amsterdam and you walk down the river, you'll see those higher buildings that are definitely more than 3 stories long. Those are single staircase buildings. So if you've ever been in one, you've already stayed in a building that has that. And so I guess the question for the task force is this something where we could actually incentivize developers to come up with better floor plans and better buildings that incentivize more units on a single lot without actually a reduction in safety if many other countries that in the developed world already allow for taller buildings of single stories. And so that's the idea that I decided to bring before the Regulatory Reduction Task Force, something that actually reduces regulation. The second part of the bill allows for a town or a county to still have local control. So if they expressly want to decide to do that, they're going to have to bring an ordinance that has that outlined rather than just the automatic full adoption of the International Building Code. So they would have to say, we also want to have less than, we want to have this 3-story requirement or less than 6 stories in our specific municipality or county.
What I'm curious about is, what, as the law currently sits right now, is there any requirement to have more than one stairwell under the typical codes and building codes in Wyoming, or counties or ordinances? Do we know an answer to that?
Mr. Chair, if I may. So the code currently does allow for alternative methods and materials to include a different means of egress, meaning that in a local instance, a smaller lot or a lot that is somewhat undesirable or undevelopable in a traditional means, that can be brought forward to cover in the international codes as adopted. This is how we achieve the intent of the code. Not, you have to have 2 exits, you have to have this, you have to have that, done, so on and so forth. What it allows for is the designer, the owner, and the authority approving to have the conversation of, will this work? The key elements of will this work is every local fire department being at that table, because every one of our local fire chiefs, every one of our local fire resources are unique in what they provide to their community and what they have the ability to do. So when we talk about some of these European models, the European models are very strict and the fire departments are equipped identically throughout most of those nations. What we have here in Wyoming is every community that has a fire department is absolutely unique and has different response models, whether it be the levels of staff, the folks on that staff, their availability to get to the station, all of those things, the resources they have within those halls and stations. So the way the code currently reads is they have that opportunity. They have to, it's burdensome in the essence of they have to present that to get everybody to the table to have the conversation. It's not impossible. It's just getting those people in the room so they approve those unique instances in each community.
Mr. Chairman, to answer your question, by default, most of our municipalities adopt the International Building Code. So both the International Building Code and the National Fire Protection require either 4 or 3 stories unless they go through some sort of exception process, as Mr. Matthews outlined.
So in essence, this just makes it easier. And in fact, the way this is crafted, you can build with 1 staircase unless they find that there's a safety code in one fashion or another. And then, but in other words, the ball moves to their court, not the other way around.
Mr. Chairman, yes. So it basically sets a statewide default of 6 stories. And then if a municipality or county wanted to reduce that down, they still could.
Okay, any public comment on the bill? Come on up, Richard.
Thank you, Mr. Chairman and members of the committee. Richard Garrett, I'm a resident of Cheyenne, and my wife and I recently purchased a condominium unit in which we're now living here in Cheyenne. It's a 1960s vintage concrete building, 5 stories. It does have 2 emergency stairwell exits. They are completely constructed out of concrete. And our building is facing a choice on how to handle an upgrade or an update to our HVAC system. And that system presently costs, a replacement cost is about $500,000. We could pursue an alternative method of retrofit if we could convert one of our existing stairwells into a conduit, if you will, a riser, if you will, for newer technology HVAC systems. In the configuration of our particular building, the design, no residence door is further than 20 feet from either one of these emergency exit stairwells. So the conversion of the stairwell to this alternative use that I'm describing would be advantageous to us, and I don't think would represent a compromise in building security or residence safety. As I read the bill, this is in effect retroactive. I'm not sure if that's the right term, but it would apply to potentially apply to existing construction as well as to new construction. If that's not the case, if that is not the way that LSO or you all interpret the bill, I would appreciate your consideration of that. If the bill moves forward, I promise that I will get our board to consider this issue at its next annual meeting, which is later this month. And I'm confident that they would endorse the bill as I've hypothesized it might apply to our particular circumstance. So I give this to you as a real world example here in Cheyenne of something that could be of benefit to certain numbers of your constituents, and I'm happy to answer any questions.
Okay, questions for Richard? So, your residence, it's in the residential group R2?
Yes, sir.
Okay. Any other public comment? Thank you, Richard. Seeing none, we'll close public comment. Is there a motion on the bill? Moved. Is there a second on the bill? Moved and seconded. Discussion.
Mr. Chairman, I just have a question about it. It seems as drafted, the default then is that you just have to have one exit for up to 6 stories unless the city decides to do it differently. And it doesn't matter how big the building is. That is, how many feet you have to travel to get to the outdoors, right? So the egress path is the same whether it's 50 feet or 200 feet, I guess. And I don't know much about this topic area of public safety. So public safety is just the issue here, and maybe our fire marshal, maybe someone else can pitch in as to, are there any safety implications of what we're doing? Obviously, I'm all in favor of reducing regulatory burden and creating lower housing costs, but also don't want to unnecessarily create some unintended unsafe condition.
Mr. Chairman?
Please.
So I believe, and maybe Mr. Matthews can correct me, that there are requirements from how far from a unit in the floor plan, how far from that egress to a stairwell that they have to be. And so even if we change that requirement to only 1 instead of 2, they still have to be within some distance from that egress. If you look at the link that I sent in the floor plan, there's like a link for quote unquote illegal floor plans. And so you'll have situations where they'll be within distance from one staircase, but not to another staircase. And that way you don't have to have that corridor in between. And so you could have different configurations of different units as well. So I think that restriction would still be in the International Building Code or the fire protection codes, regardless of whether we change it for 1 or 2.
Mr. Chair, to speak additionally to that is what we will do in creating this piece of legislation is create a conflict, because now we have a statute that will, or an ordinance at a local level that can particularly impact the conflict of the codes. As the current codes are adopted and written, it's a consensus model. So the fire code complements the building code, the mechanical code, the plumbing code, the existing building code. All of those are in concert, so the language in one reflects the changes in others. So by doing this, we're potentially creating that conflict at a local level that now someone's going to have to potentially legally interpret, whether it be a code of appeals that goes to the next level or to court after the third level. That's a hurdle and a challenge. The process, so this isn't an issue that's unique to Wyoming. This is being talked about in multiple jurisdictions across the country. There are jurisdictions that have done it on a local level and created this conflict, and now they're trying to come back and rectify that. Most recently, all of the international or the state local officials have gathered. So we had our International Association of Fire Chiefs, our Code Council folks, we had our Metro Chiefs. They all came to a consensus on the way to do this is to put it in the code. If we want to create a single stair, put it in the document so it would be considered in the 2027 code as an amendment that would allow for this to happen, that now all of the codes are in concert. So now all of the rules are together as opposed to a one-off in Wyoming, or when we go to an ordinance level, that ordinance gets crafted in X number of municipalities.
So do you know whether or not that Mr. Yano's correct that there are multiple stairs required if based upon distance from fire exit?
The one particular, Mr. Chair, the one particular reference I have is, yes, there is in section 1017 of the building code talks about a travel distance not to exceed 125 feet. That also, the reason 125 feet comes in is then it's all the other building systems in place. Is it sprinkled? Does it have smoke control? So on, fire alarm, multiple other contributing factors. And that's where this one-off creates that conflict, because now we have to figure out how do we take the code section in this book and the ordinance or statute section in this book and make sure that they're cohesive.
Okay, further questions? Any closed public comment? Any more public comment? Closed public comment, discussion on the bill?
Mr. Chairman, sorry to belabor the point, but to Representative Yin, it seems that if we pass this as drafted, then there will no longer be a maximum egress length that's allowed, because this bill says, notwithstanding any other law to the contrary, no state agency shall require more than one exit, period. So it won't matter if it's 125 feet or 300 feet or 500 feet. The city won't be allowed to demand a second exit, right, as drafted. And then you've got the statute just overriding the building code. And I mean, the statute overriding the building code doesn't bother me so much as long as we're doing consistent with public safety. What kind of concerns me is if we're inadvertently creating in extreme situations something that's unsafe, right?
Mr. Chairman. So what I would say is that I think it would still have to satisfy the other parts of the building code. So if you have a site plan that doesn't allow for an egress within 125 feet, then you just wouldn't get it approved anyways because it wouldn't fit the building code. So you would create a site plan that has another way for someone to egress within 125 feet, but you just wouldn't have that requirement to have access to two egresses within one unit, right? So that way you still fulfill the statute and you fulfill the building code. So you wouldn't be required to build two staircases. You would just be required to build a way for an egress within 125 feet. And if you are building a site plan that's very long, then the easiest way to do that would be to build another staircase, but you would still have the flexibility of having different floor plans than you would be if you had to forcibly create a hallway in the middle of a building that would require units to be smaller than they could otherwise be if they had a floor plan where you had two staircases on either side and you had units that could span the entire width of a building instead of being cut in half by a hallway. So I don't think there's really that much conflict there. I think you could still build those buildings and you don't create that safety issue, in my opinion. But it's up to the task force on whether they believe this is something that doesn't actually compromise fire safety, because I don't believe it does. And on the secondary part of Mr. Matthews' statement, I don't think we should be waiting for a non-governmental entity to decide what we should do in the state of Wyoming.
Go ahead, Ms. Reed.
Mr. Chairman, I know there was one issue that I've been diving into the housing issue over the last few years about maximum height restrictions, and well, a lot of municipalities in Wyoming have maximum height restrictions. And one of the things that was flagged for me is that if we were to change that at the state level, there may not be the equipment in the fire departments. And I think Director Matthews kind of alluded to this. I guess I just did want to kind of circle to that question is if you're talking about 6-story building and if this is creating a means to allow for those when a municipality doesn't have the firefighting equipment to serve a 6-story building, are we creating an issue there? And then I guess Representative Ian, I like your point is we should always take things on in Wyoming when we can. But is there any appetite in sending a letter from this committee to the folks who are going to work on this code and ask them to consider this? Because that would also then I think create a little bit more of the dialogue about that code always needs to be nimble too.
And to follow up on that, why would you need to have 6 stories? Why don't you just make it 3 or 4? Is there?
Mr. Chairman, so my desire for the Regulatory Reduction Task Force was a way to remove regulations that allows for more construction of housing. And so that was the reason I brought it forth. I don't even take away local control in this aspect. So if a municipality feels like it is infeasible for them to provide fire protection for 6-story buildings, then again, they can just create an ordinance that doesn't allow that. It's explicitly in the bill to allow them to do that. So the desire was, how do we reduce regulation across Wyoming? And I still preserve local control and create a way to increase the density for any particular lot.
Okay, any further discussion on the bill? Seeing none. Question? Roll call.
This is a roll call vote to forward 25 LSO 0250 multifamily dwelling stairwells to the committee of the chairman's choice. Senator Driscoll. Senator Jones. Senator Schuler.
That's after I had COVID. I can't. No.
Who had COVID?
Representative Davis.
Go ahead.
Representative Davis.
No.
Representative Stith.
No.
Representative Yin.
Aye.
Director Matthews.
No.
Director Parfit.
No.
Mr. Bebout.
No.
Ms. Delancey.
Excused.
Excused. Mr. Martin.
No.
Ms. Olson.
No.
Mr. McKay. Mr. Napier.
Nay.
Mr. Malm is excused. Co-Chairman Grew.
Aye.
And then Chairman Nicholas.
Aye, and that's 8 to 7, I believe, right? So I get my numbers right?
That is correct.
All right, so the motion, the bill fails, 8 to 7. Okay, it's 12 o'clock. Let's break for lunch. I know that Ms. Delancey doesn't get back till 1:15, so we'll reconvene about 1:20.